Article 21. Every Argentine citizen is obliged to bear arms in defense of his country and of this Constitution, in accordance with such laws as the Congress may enact to that effect and with such decrees of the national executive. Citizens by naturalization are free to render or not render this service for a period of 10 years counted from the date on which they obtain their citizenship papers. Article 22. The people do not deliberate or govern except through their representatives and authorities created by this Constitution. Any armed force or meeting of persons that attributes to itself the right to stand for the people and to petition in their name, commits the crime of sedition. Article 23. In the event of internal disorder or foreign attack that endangers the exercise of this Constitution and of the authorities created thereby, the province or territory in which the disturbance of order exists shall be declared in a state of siege and the constitutional guarantees shall be suspended therein. But during such suspension the President of the Republic may not convict or apply punishment upon his own authority. His power shall be limited in such a case, with respect to persons, to arresting them or transferring them from one point of the nation to another, should they prefer not to leave Argentine territory. Article 24. Congress shall promote the amendment of all categories of existing legislation, and the establishment of trial by jury. 25. The federal government shall encourage European immigration, and it may not restrict, limit, or burden with any tax whatsoever the entry into Argentine territory of foreigners whose purpose is tilling the soil, improving industries, and introducing and teaching the sciences and the arts. Article 26. Navigation of the inland rivers of the nation is free to all flags, subject only to regulations enacted by the national authority. Article 27. The federal government is bound to strengthen its relations of peace and commerce with foreign powers by means of treaties that are in conformity with the principles of public law laid down by this Constitution. Article 28. The principles, guarantees and rights recognized in the foregoing articles may not be altered by the laws that regulate their exercise. Article 29. Congress may not confer on the national executive, nor provincial legislatures on the provincial governors, extraordinary powers, or the whole of the public authority, nor grant them acts of submission or supremacy whereby the lives, the honor or the property of Argentines will be at the mercy of governments or any person whatsoever. Acts of this nature shall be utterly void, and shall render those who formulate, consent to or sign them liable to be called to account and punished as infamous traitors to the country. Article 30. The Constitution may be amended in its entirety or in any of its parts. The need for its amendment must be declared by the Congress by a vote of at least 2/3 of its members, but the amendment shall not be accomplished except by a convention called for such purpose. Article 31. This Constitution, the laws of the nation that as a result thereof may be enacted by the Congress, and treaties with foreign powers, are the supreme law of the nation, and the authorities of every province are bound to conform to it, notwithstanding any provision to the contrary which the provincial laws or constitutions may contain, except, in the case of the province of Buenos Aires, for those provisions established by the treaties ratified following the Pact of November 11, 1859. Article 32. The Federal Congress shall not enact laws that restrict the freedom of the press or that establish federal jurisdiction over it. Article 33. The declarations, rights and guarantees that the Constitution enumerates shall not be construed as a denial of other rights and guarantees not enumerated therein, but which issue from the principle of the sovereignty of the people and from the republican form of government. Article 34. The judges of the federal courts cannot serve at the same time as judges of the provincial courts, nor does federal service, whether civil or military, confer domicile in the province in which it is performed, and which is not the employee's habitual domicile, this provision being understood for the purpose of applying for public office in the province in which the individuals happen to be. Article 35. The designations successively adopted from 1810 up to the present, namely, United Provinces of the River Plate, Argentine Republic, and Argentine Confederation, shall henceforth be official names used indiscriminately for the designation of the government and territory of the provinces, the words Argentine Nation being used in the enactment and sanction of laws.